Okay, so we finished right before our break, and we're actually now on the home stretch. Yeah, you guys have made it. So we were talking about a disability and the request, and these, excuse me, why does that happen? I didn't cough at all on my break, and as soon as I start back, so sorry. With regards to the request for the reasonable accommodation, again, just we're going to recap it because we're going to move on to the next category or the next subject, but just making sure you understand what is required of a housing provider. We just have to make sure that the person's request meets the definition according to the Fair Housing Act as a disability, describes the needed accommodation, and we need to be able to make the connection, the nexus between the request and the disability. Who can verify? I mentioned each of these on the preceding page. I believe it was probably at the bottom of page number 19. Regarding getting a medical professional, peer group support, non-medical service agencies such as a caregiver or home care services, and a reliable third party who is in a position to know about the individual's disability. In this case, as a last example, I believe it's the last example, under request, it says an applicant with an obvious mobility impairment who regularly uses a walker to move about request an assigned parking space near the entrance to the building. That is when the disability is obvious, we don't need to verify. But when there's not obvious, then we do need to verify. But we don't need to inquire if the disability is obvious. If there's the request and the disability, the connection is there. What can I ask? You do not inquire if disability in the nexus is obvious. May I install a ramp for my wheelchair? That's obvious. You don't need to make any other assessments except to now look to see if we're going to be able to reasonably accommodate this individual's request. All right, good people. Let's turn over now to page number 21, because now we're going to look at the next protected federal list. I'm sorry, I'm stuttering. Fair housing violation or fair housing protection, which is sexual harassment. Now, we don't protect sexual harassment, but the law specifically speaks against sexual harassment. It is against the law. Sexual harassment, top of page 21. And housing includes demands for sexual acts in order to buy, rent, or continue renting a home. So it is a form of sexual discrimination that is prohibited by the act. And the act we're speaking to is the Fair Housing Act. Harassment, coercion, intimidation, threats, all of those are considered, fall under sexual harassment, which is prohibited. So let's look at some documentation from the Justice Department Civil Rights Division announced the Sexual Harassment and Housing Initiative, or SHHI, in October of 2017. This initiative is an effort to combat, was created in an effort to combat sexual harassment in housing, led by the Civil Rights Division of the Department of Justice. So this is the Department of Justice I mentioned early on when I said that they are responsible jointly with the HUD agency for enforcing the Fair Housing Act, and the DOJ is the actual department that will bring the lawsuit against an individual based off of a reference from HUD. So it specifically seeks to increase the department's effort to protect individuals from harassment from landlords, property managers, maintenance workers, security guards, and other employees and representatives of rental property owners. In 2017, the Department of Justice recovered more than $1 million in damages for harassment victims. So it is important not only from the perspective of the employer, but also the management company to have procedures and policies in place for understanding what sexual harassment is, that it is against the law, what those consequences may be. And let's say you have, it's not just the residents that may file a sexual harassment suit. It could be someone from the management side, the manager, assistant manager, leasing professional, maintenance supervisor, maintenance team. So what are your procedures in place? It's important that you know what your policy procedures are. Sexual harassment is defined as unwanted sexual advances, comments, and touching offering to reduce, overlook, or excuse later rent payments in exchange for sex. This is that quid pro quo, this for that. Offering to reduce, overlook, or excuse deposits in exchange for sex. Evicting or threatening to evict tenants who object or refuse the sexual advances. Demanding or pressuring tenants to potential tenants to engage in sexual acts in order to keep their housing. Refusing needed maintenance service to those who refuse the harassment. Entering the homes of tenants without their consent. All of these is what is considered sexual harassment. And there's a specific landmark case that I just wanted to also, and creating a hostile environment. Can't forget that as well. But there's a landmark case that I actually want to mention to you all about, because when I first read about it a couple years back, I was like, wow, this is a big one. And it speaks to sexual harassment. So there was a case out of Baltimore, Maryland that was actually settled in back in 2016. And it was a class action lawsuit brought by 19 women against, and again, it's the city of Baltimore, 19 women, class action lawsuit brought against the Public Housing Authority. The case was settled. It was a landmark case. It was settled for $8 million, okay, in this class action lawsuit. And it was filed by public housing tenants who were asked to do sexual favors in exchange for repairs. That goes back to that quid pro quo, sexual harassment. I'll do this if you give me that. It was the largest, as of a couple years ago, it was the largest settlement in fair housing history for sexual harassment. So you have to know what your policies are. Knowing the policies mean that you abide by those rules and regulations, because it can be very costly. It cost the Public Housing Authority $8 million. That's a lot of money. That's a lot of money. And that can also be, it could be for a private owner as well. So fair housing cases can cost, and it can really dig in the pocket, and they can also cost that particular owner, bar them from particularly doing business in the future. Hostile environment sexual harassment is means being subjected to unwelcome sexual advances, requests for sexual favors, or other verbal or physical conduct of a sexual nature. So again, that quid pro quo is this for that. Sexual harassment behavior are defined as, it can be verbal, it can be by way of sexually explicit questions or jokes, communication, electronic, oral, or written, visual, images, videos showing someone of what you think is a funny video on your phone that turns out to be not quite so funny to the other person. Written by way of email or notes, nonverbal, our eyes tell it all, don't we? So nonverbal, looking someone up and down, making derogatory gestures, or physically, repeatedly standing too close or brushing up against a person, grabbing and or touching. Those are considered sexual harassment, descriptions of sexual harassment behavior. With regards to, turn to page number 22, sexual harassment can occur in a variety of circumstances, and if found guilty of sexual harassment, the owner can be required to pay monetary damages to the victims, a civil penalty to the U.S. They could end up losing their job, and I've just mentioned this, potentially being barred from continuing to serve as a property management company. So, these as an employee of a company, not only is the employer obligated to you, but you're obligated to them as well, and you work in tandem. And we need to make sure that everyone is equipped with the rules and regulations so they know what not to do, so that nobody finds themselves in this sticky situation. When you look on page 22, it says management's responsibilities under Title VII, as amended, cover employers must take reasonable care to prevent sexual harassment, take reasonable care to promptly correct sexual harassment that has occurred. If management fails to investigate and take action upon receiving a complaint of harassment, this could violate the reasonable care clause, and management or representative of the management may be held liable. So, management is responsible to making sure that when a complaint is brought to their attention, they have a procedure in place to address it. Don't just blow it off and say, oh, well, that person, that's just who they are. That's not acceptable. What are your protections to cover your team members? What are your protections to cover your residents? What's in your policy? Employer management responsibilities, you got to keep relationships professional, okay? You keep relationships professional between management and your residents. Communicate clearly. Best practice is to have a sexual harassment policy in place that prohibits sexual harassment and provides information on how to report a complaint. Again, I stress to you, managers are liable for the actions of their employees and for the action of their own or inaction to address an issue. They must be well informed of the company policy and be swift to implement when it's necessary. So rounding out again, the best practices, for management companies, landlords, and management teams with regards to sexual harassment, make sure you adopt a sexual harassment policy. Outline what those types of behaviors that are unacceptable, and people work best when they understand consequences. So outline what the repercussions are and create what is your tenant complaint procedures. But most importantly, look at this. Make sure all staff, I said it before, I'll say it at the end of the training, make sure everyone is trained on fair housing requirements. Let's look at disparate impact on page number 23. Top of the page says disparate impact is a facially neutral practice, procedure, or policy that does not appear to be discriminatory on its face. Rather, it is one that is discriminatory in its application or effect. So in 2016, HUD provided guidance with regards to the application of Fair Housing Act standards to the use of criminal records by providers of housing and real estate related transactions. Here's what it said. In this memo or guidance, it addressed the Fair Housing Act and how it applies to use of criminal history, because we're looking at, disparate impact, which, again, just to back up a little bit, it's a policy or procedure that was created, can be created, that may seem neutral in its creation and fair, but it ended up causing a disparate impact because it did end up discriminating against a particular class of people. So on its face, it wasn't designed to be discriminatory, but that's exactly what the impact of it was. This HUD memo, in addition to addressing criminal history and how to apply it with the Fair Housing Act, it addresses how the discriminatory effects and disparate treatment methods of proof applying which the housing provider justifies an adverse housing action based on an individual's criminal history. I want you to look still on page number 23, because under disparate impact, it mimics what's on the slide. It says a housing provider violates the Fair Housing Act when the provider's policy or practice has an unjustified discriminatory effect, even when the provider had no intent to discriminate. Examples of practices that may potentially cause an issue: use of credit scores. Co-signers. If you need a co-signer, example can be if under certain credit score or if a student. Remember, we are in the position of providing decent, safe, and sanitary housing. Income that is 4 times the rent requirement. Crime provisions and lease requirements are house rules that do not take into account the impact on victims. Here's an example of disparate impact. A development has 2 sides, one for rental, the other for buyers. Now, a policy was created that says that it was only to rent to or allow buyers that were gainfully employed. Well, you would think, okay, that makes sense. People, we're going to give you keys to a multi-million-dollar asset. We need to make sure you can pay your rent, right? But this type of policy has a type of disparate impact against people with disabilities who have a much higher unemployment rate than the general population. So again, disparate impact goes back to, you did not mean to have this policy. It was neutral. It was a policy that thought was cut and dry, but yet it ended up causing a disparate impact on a particular protected class of people. So when creating policies, these are issues that can arise, and you have to make sure that they are thoroughly addressed by management and possibly legal counsel before you enact them, before you make them effective. Persons having a criminal record, going back to disparate impact, are not protected under the Fair Housing Act, but HUD stresses Criminal history-based barriers to housing have a statistically disproportionate impact on minorities. Creating arbitrary or blanket criminal-based policies or restrictions could violate the Fair Housing Act. Again, we get all of the, I say it, I'm gonna keep saying it, we get all these blanket rules and regulations for fair housing, but you gotta peel back layers. It's constantly peeling back layers to make sure that you understand every single facet of those policies and how to apply them. If you turn to page number 24, and we'll look real briefly at, we're going to keep going with the screening procedures. Here are steps used to analyze, I'm on page 24, claims that a housing provider's use of criminal history to deny housing opportunities result in discriminatory effect of the violation of the act, which is the Fair Housing Act. We have exclusions because of prior arrest, exclusions because of prior conviction, and screening versus discriminatory practice policies and procedures. So looking at exclusions because of prior arrest, it says a housing provider with the policy or practice of excluding individuals because of one or more prior arrests without any convictions. It does not provide a burden of proof that the policy or practice is necessary. So the Supreme Court's stance on this is with regard to, fair housing. It says the mere fact that a man has been arrested has very little, if any, probative value in showing that he is engaged in any misconduct. Again, there are policies for when we do a background check, what's going to be, I call them a deal breaker. There are things that are a deal breaker. There are things that we cannot work with. And there are other things that we have to be careful of the policies that are set in place. Okay, because we know sex offenders, that's deal breaker. We can't do anything with that. But what about your other policies based on arrest, based on conviction, your screening practices? Let's look at the next one. I'm kind of paraphrasing, not reading it all because it's here for you as reference. But under exclusions because of prior conviction, it says in most cases, a record of conviction will serve as sufficient evidence to prove that an individual engaged in criminal conduct. However, HUD has stated if one incorporates a policy or practice that excludes a person with prior convictions, must still be able to prove that such a policy or practice is necessary to achieve a substantial, legitimate, or non-discriminatory interest. So all of these have to be dissected to make sure that it's not causing a disparate impact. Screening versus discrimination policies and procedures, the focal point here when developing criteria that ensures we are applying screening criteria and policies and procedures are aimed at the resident's safety and protecting the property. And we mentioned that earlier with direct threat. It's often considered to be among the fundamental responsibilities of a housing provider and needs to ensure that there are no violations to the provision of the Fair Housing Act. Again, policies and procedures, making sure that we're not causing a fair housing violation, disparate impact. So that's, again, it's there for further reference for you, but it's a synopsis of those three, those different steps to analyze with regards to exclusions of prior arrest, prior conviction, and understanding screening and discriminatory practice. So basically, in summary, here's what you should do. Here's my best advice. Have written policies. I keep saying it. I told you you're going to hear me say it all throughout the day. And procedures that outline program and property eligibility and provide to all interested applicants. Please apply all screening requirements consistently and be prepared to consider requests for reasonable accommodation. Have written policies and procedures that demonstrate how maintenance requests are addressed and when late fees are imposed. For example, again, this goes back to what we had mentioned earlier with regard, it's under screening procedures, but it's in regards to having procedures in place. Crime-free nuisance ordinances. I want you to look on page number 25 at the very top. It says crime-free ordinances are becoming increasingly popular. Local cities and towns are adopting these, but not reading the fine print, as they violate the Fair Housing Act. Terminating the lease of residence based on arrest records can be risky. as the data shows, a disparate impact against African Americans. Refusing to house an applicant with a criminal history that occurred long ago or involved minor crimes may also violate the Fair Housing Act due to disparate impact. Again, these are things that have to be explored when creating policies. This is why it's nice to have a group of people. It's not just one person that makes the policy. It's management, it's legal counsel. They put their expertise together to create policies that do not cause a disparate impact. With regards to nuisance orders, it says nuisance ordinances require landlords to evict residents whose units are the subject of multiple police calls. Okay, so we do have language sometimes in our lease where we have to enforce clauses that are, we have to enforce our lease, all right? But nuisance ordinance are one of those that it can be a little bit tricky, and we have to have policies in place for instances, especially that's going to lead us up to talking about the VAWA protection. HUD sent a notice on September 2016 that warns that requiring landlords to evict residents with multiple police calls may violate the Fair Housing Act. It may cause residents who are victims of domestic violence to avoid calling the police. We do not want to punish victims of domestic violence who call the police, okay? Because obviously, if it's a part of a written part of the lease, part of the requirement of occupancy, but that problem person unfortunately has multiple domestic incidents, we don't want to deter them from calling for help, knowing that if I call too many times, I could be evicted and lose my home. VAWA prohibits denying housing to victims of VAWA prohibits denying housing to victims of domestic violence. This is a good segue for us to talk about the VAWA legislation and fair housing. Bottom of page number 25, it says the HUD 2001 FHAA, and this is Fair Housing Economic Opportunity Notice on domestic violence, says that women are overwhelmingly victims of violence. No, sorry, I've skipped down. Women overwhelmingly are victims of domestic violence. The US Bureau of Statistics says 85% of victims of violence are women. It's estimated at 1.3 million victims of assault by an intimate partner each year. 1 in 4 in their lifetime will experience intimate partner violence. And I do want to correct this because this is actually 1 in 3. And I saw it on the latest legislation reauthorization report from the Biden administration, but they said 1 in 3. So this number's changed. In 2009, women were 5 times more likely the victims of domestic violence. Now let's look at the VAWA legislation. Violence Against Women Act. Now please note, and I'm going to read in the coverage for VAWA what it covers. Now women, it doesn't just cover women, it covers all sex, male and female. Reauthorization Act of 2019. VAWA did not amend the authorizing statutes for the newly covered housing programs, but it does tell us who is responsible for adopting policies and procedures with VAWA protections. Nope, right here, there it is. All victims of domestic violence, dating violence, sexual assault, stalking, regardless of sex, gender identity, or sexual orientation. These policies must be applied consistently with, oh, I clicked on it too fast, I apologize. Must be applied consistently with all non-discrimination and fair housing requirements. So the VAWA protection is actually would be a case that the Department of Justice would hear because it is a federal crime, Violence Against Women's Act, which was, again, it was actually, for those of you out there that didn't know, it was reauthorized just a couple weeks ago, March 17th of this year. So that was by the current administration. So it was very good because it expired. The act didn't expire, just it being reauthorized expired. I believe it was in 2019, which means that those provisions that had been locked in since 2013 were still static all the way to 2019, or actually to 2021, because, when reauthorizing means that you add provisions and coverage to the act, because unfortunately things change with the world, and we want to make sure that individuals are covered we update it with certain different provisions in the reauthorization. On page number 26, it just further defines what the Violence Against Women's Act is. Although again, I stress to you, it covers all victims of domestic violence. There are certain HUD forms that are listed that were added to the HUD clips, which is basically like a client portal that gives policies and updated policies and systems for HUD. But there are certain, when you're dealing with the HUD agency and HUD at a property, there's certain forms that you need to have, that you present to an applicant, to a current resident, even when they move out, for them to understand what their protections are based on these particular VAWA legislation and these particular forms. And those are outlined on page number 26. Let's look at advertising, discriminatory advertising. So when we talk about, you know, advertising, and I mentioned one of the prohibited acts, you have to be careful how you describe your property. You want to describe the amenities and not the people you want to attract to the property. And that's what it says here. Words matter. Describe the amenities, not the tenants. You should not ever give the impression that discrimination is acceptable through your advertising. And whether you advertise by way of flyers, brochures, signs, banners, posters, billboards, even anything, whether it's written, whether it's oral, whether it's electronic, you are responsible for making sure that you do not discriminate in your housing, do not discriminate in your advertising. It is unlawful to make, print, or publish, or cause to be made, printed, or published any notice, statement, or advertisement with respect to the sale or rental of a dwelling, which indicates any preference, limitation, or discrimination because of race, color, religion, sex, handicap, familial status, or national origin. With regards to discriminatory advertising, the use of words, phrases, symbols, and forms that describe a dwelling, landlord, tenant, and protected class may indicate a possible violation of the Fair Housing Act. For instance, you have to be careful when in your advertising, you don't want to say Latino community, singles community. These are just examples. No children allowed, Hungarian community, or we're close to churches or close to a particular church. These are avoided phrases you want to use, just a few of many that you want to avoid in your advertising. When you're looking at, on page 27, when you want to include either the Fair Housing logo in your advertisement or the slogan here or the statement. We are pledged to the letter and spirit of U.S. policy for the achievement of equal housing opportunity throughout the nation. We encourage and support an affirmative advertisement and marketing plan in which there are no barriers to obtaining housing because of race, color, religion, sex, handicap, familial status, or national origin. This is transparency and disclosure to we are an equal housing opportunity provider and we do not discriminate. So the Fair Housing Act, it encourages you to use either the logo, the slogan, or the statement, whatever will fit on your advertising. As far as the Fair Housing poster, page 27, there are requirements actually it's on page 28, because there are requirements with regards to, well, let me take your eyes to 27 for a minute, right at the bottom. So there are advertising requirements when it's a print ad and when it's a non-print ad, okay? And it gives you recommendations based on the size of the ad and the size of the logo. That's what's at the bottom of page 27. Then if you turn to page 29, it speaks about the Fair Housing poster. It says all multifamily rental properties must post a Fair Housing poster at the beginning of construction throughout the rental. This is full disclosure to we are equal housing opportunity. The poster must be 11 by 14 in size and prominently displayed to be readily apparent to all seeking housing. Failure to display the Fair Housing poster as required is evidence of discriminatory housing practice. So yes, that is written as a part of the HUD regulations. So you want to be aware, this is why you have to have that equal housing opportunity poster in your community, at your community. And the in the office, okay, where your traffic is going to come in, your foot traffic is going to see these things. So let's do this last workshop. I think it's 2 of them here. This might be our last ones for the day. It says Trista's a manager at Lindell Tower Apartments and is posting an ad online to attract prospects. So to describe the location, she writes this: shares parking lot with River Church in the description. Describe what is wrong and suggest better choices. What is a different way to describe the property location? So this is one that goes back to understanding discrimination, non-discrimination based off of religion. Now, it was innocently done where Trista said the location shares a parking lot with River Church, but this could indicate our property has a preference for those of whatever religion River Church is. We have a preference for those individuals for housing at this property. That's maybe not what the procedure is at the community, but this is why HUD wants you to avoid, the Fair Housing Act wants you to avoid giving landmarks such as churches as directions to your property. Instead, what Trista could have said was make a right in given directions, make a right at the community entrance sign or your monument sign. I just named a community entrance sign that says Lindell Tower and the leasing office is the first building on the right. So guiding them, giving them directions to your community without listing the religious institution that you share a parking lot with. Okay, look for the Lindell Tower Apartments monument sign on your left, and the clubhouse is right there, or the leasing office, excuse me, right there on the right. Next one says Waverly Apartments has several vacant units to fill, so they create a flyer to distribute at a local after-school care facility. On the flyer, they market the community as the perfect place for families and describes all of the amenities with special attention to the tot lot and playground for children. Well, what's wrong with this advertisement? This advertisement is not only being distributed to the local after-school care facility, but it's also giving that indication that, let's say I'm a single person and I'm looking for housing and I love this community, it's in a great location, I've been considering living there, but I see this flyer and it's telling me they really are just looking for a community with children. They're looking to have a community that has children. So I'm not allowed there because I'm single and I have no children. These are buzzwords you want to stay away from. That's not remaining neutral. And remember, we mentioned about equal opportunity and remaining neutral and consistent. This is why you have to do it with advertising as well. You can get in deep, deep trouble with advertising because this is screaming families only, and I don't have a family, it's just me. All right, disability civil rights laws, page 29. Now, there are 3 civil rights laws that provide persons with disabilities protection against discrimination in our housing communities. One is Section 504. Several of you might have heard of those 504 requirements. It is quite a few. Section 504 has got a whole anthology in and of itself. Those regulations are probably about this thick. But it's good because, again, it's geared to making sure that those that are disabled have equal opportunity in housing as those without a disability. We want them to have equal access. Fair Housing Amendments Act and the Americans with Disability Act. All of these cover any person who has a physical or mental impairment that substantially limits one or more life's major functions, or one or more life's activities, excuse me, or has a record of such impairment or is regarded as having such an impairment. Section 504, which was written into law in 1983 or 73, excuse me, says no otherwise qualified individual with handicaps in the United States shall solely by reason of his or her handicap be excluded from the participation in, be denied the benefits of, or be subjected to discrimination under any program or activity receiving federal financial assistance from the Department of HUD. So HUD, this was based off of protections for those with disabilities and federally subsidized program. And again, it prohibits discrimination against disabled persons. Federally funded projects such as HUD, Rural Development, and Home Funds have to have 504 rehabilitation requirements. But believe it or not, the tax credit program is not required to, because they're not received. The tax credit program is not a federal subsidized program. It's based off restricted rents. Now, a lot of those properties do abide by the 504 rehabilitation, requirements, but they're not required to under the act. The requirements under, that went by too fast. 504 says what you cannot do is deny the opportunity to participate in a program, service, or activity due to their disability. Cannot deny or refuse to rent housing to a person with a disability. Cannot impose specific selection criteria, fees, or conditions that are different, basically, than those individuals who are not disabled. Can't require these persons with disabilities to live on certain floors or in certain areas of the community. Refuse to make repairs or limits access to public or common areas, parking privileges, or services available that are available to other residents. Can't deny the opportunity to participate on advisory or planning boards. So it gives, 504 has a lot of different regulations, but this is just a small requirement of those things that are not required versus what is. So turn to page number 30, please, because actually we were there, and I'm sorry, I hadn't flipped my page yet, but we're on page 30. It says the requirements, section 504, make and pay for reasonable structural modifications to units and our common areas. You're responsible for providing auxiliary aids and services necessary for communication, perform self-evaluation of owners' programs and policies, develop a transition plan, operate programs in the most integrated setting, provide newly reconstructed and rehab programs. So when it goes back to here, providing auxiliary aids and services for those individuals with the disability, it says 5% of the units must be accessible, and 2% must be audio visual capable. Again, it's very specific points. Before we turn to page number 31, I wanted to go up to the gray box on page 30, because just important for, this is a good takeaway for you. For the 504 requirements, just a few things I wanted to highlight. This was the first federal civil rights protection for persons with disabilities, okay? I'm not reading them all because there's some I picked out which are really good takeaways. They're all good, but these are particular ones I wanted you to have as a takeaway. The section 504 is enforced by HUD's Office of the FHAA, Fair Housing Equal Opportunity. 504 has to be, those requirements are applicable at HUD, Rural Development, Housing, Home, CDBG, Community Development Block Grant properties, but not the LIHTC program. So again, all of those programs that are listed outside of LIHTC are federally subsidized properties. Section 504 actually came before the Americans with Disabilities Act, but 504 led to changes in the building code under the ADA. And we'll talk about the ADA in a second. Now I want you to turn to page 30 at the very top for Fair Housing Amendments, FHAA, and looking at the different key points that are there. This was signed into law in 1988, and in 1988, remember, we had the Fair Housing and Disability protected classes that were added, and it became effective in 1989. It amended the Civil Rights Act because, again, it added disability and familial status. It extended fair housing protections to persons with disabilities as well as children. Adopt the same definition for person with disabilities as section 504, and it's enforceable by HUD, the FHEO, Fair Housing Equal Opportunity. You cannot refusing, this is a violation of the law, refusing to allow tenants with a disability to make modifications to a unit or common areas at the tenant's expense. Can't do it. We can't also ask what is the person's disability, and we cannot ask them if they can live independently. It is none of our business. With regards to the ADA, I laugh because I said it's none of our business. With regards to the ADA, Americans with Disabilities Act, I just mentioned that that was signed into law in 1990, and the ADA was the nation's first comprehensive civil rights laws that addressed the needs of persons with disabilities, and it addressed those areas that it covers, such as employers. It outlined for employers what was required, commercial spaces, public areas such as offices and other public areas. So it says it addressed, I'm reading from the gray box, addressed discrimination against disabled individuals by employers in commercial spaces and in public spaces. So again, equal opportunity for individuals with a disability. Now, what about other common areas and units? That's not where the ADA covers. That's where the Fair Housing Act covers. ADA covers all of these particular areas. Why is this important? Because you have to go back to understanding as a housing provider which policies would apply. And we kind of mentioned that earlier, where I said the ADA covers those service animals. Okay, so those animals that are trained to perform a task with a disabled person, but the emotional support animals fall under fair housing, and that is confined to units. Let's look at some fair housing design requirements. Don't quite change yet, because I want to look right here. We at the bottom of, well, let's look at the bottom, page 30. There's a Title II and Title III that did speak to regulations from the Department of Justice at the bottom of page number 31, where it says non-discrimination on the basis of disability by public entities. So it gave some guidance to non-discrimination in public entities for those that have a disability, as well as in public accommodations and commercial facilities. So there are certain requirements that are required at certain sectors, I guess, of different industries. You even have the airline. The airline has certain ADA requirements that they have to abide by that we would not necessarily find in housing. So that's what that Title II and Title III is at the bottom of page number 31. And those are regulations based off of the Department of Justice guidance for persons with disabilities. Let's look now on page number 32, fair housing design requirements. There's 7 basic requirements of the fair housing accessibility requirements. Accessible entrances and property routes, accessible and usable public and common use areas. We must, and these are design requirements. This is what we have to have. We are required to have in units to make sure that those with a disability can have access, equal access. Usable doors to common areas and throughout the units, accessible routes through the units, controls must be in accessible locations, bathrooms must have reinforcements behind the walls to allow for grab bar installation, units must have usable bathrooms and kitchens. We want for those with a disability to have equal access. That's the whole focus of us talking about this section 504 and the different design requirements. And again, that's where your maintenance teams come in, because they're very vital to, you know, if you have to make a reasonable modification to the units. Mind you, these are design features that go back to construction to make sure we can accommodate these individuals, but there may be times where you have to get your maintenance teams involved, as you know, long after the construction phase is over and you've leased up the property and you're moving along and things happen. Finally, today, we're going to look at HUD and fair housing monitoring on page number 34. So I want you to turn to 34. Just want to read right quick at the top there. It says HUD uses testers to shop properties to gather information for fair housing compliance. Now, this is sometimes known as shopping and was first approved by the US Supreme Court. So the Supreme Court weighed in on this back in 1982. This information may indicate whether a housing provider is complying with federal fair housing laws. That's what, you know, it's not always a means of, aha, I gotcha, but it's a measure to make sure that you are abiding by the rules of the program, or else it's going to be an aha, I gotcha moment. Since the passage of the Fair Housing Amendments Act in 1988, testing programs have expanded to include tests for both national origin and disability discrimination. So here's the primary focus of it. Primary focus of fair housing testing program is to identify unlawful housing discrimination based on race, national origin, disability, or familial status. So fair housing testers are out there, everyone. You have to make sure, I'm not going to say be careful, I'm going to say know the law. Knowing the rules and regulations will keep you in compliance, but do know that HUD does send out fair housing testers to test for all of those different areas of race, national origin, disability, or familial status. There are different penalties that are assessed based on civil penalties, a pattern of having a particular violation, actual damages, punitive, injunction placed against the manager, the regional manager, the company that can place them, you know, put them in the realm of not being able to suspending business. They won't be able to do business. And if you have the tax credit program at your property, you understand the importance of those tax credits, and fair housing violations are absolutely non-compliance issues at a LIHTC property. So an owner and developer at a tax credit property could lose tax credits. And we know that can just be in the thousands, if not hundreds of thousands of dollars. So with this particular slide, everyone, I'm going to conclude our training. Before you go though, just want to say a few more words. Please make sure that you stay up on your fair housing training. It is illegal to discriminate against those protected classes, and we went quite in depth of giving you examples and workshops so you understand how to apply these properly at the community, apply the rules at the community. You have to allow people to choose where they want to live based on what they're looking for, what you have available, do they meet the requirements of the program? Allow them to make the choice of where they want to live. As far as your responsibility, make sure that there are written policies. I'm sure at Wilhoit they have written policies. Make sure you know them. Make sure you have a copy of them at the property. Make sure every team member, from the newest team member to the oldest team member, oldest meaning tenure, not age, is aware of the policies. Be consistent when you apply them. Make sure that you document any reasonable accommodation, reasonable request, sexual harassment that might have been, you know, claimed at the property. Whatever happens that is a fair housing violation, you don't want it to happen, but if it does, you need to make sure that you address it. You cannot turn a blind eye to it, and you make sure that you document it, please. Ignorance is not a disclaimer for the law. I said that early on when we met earlier today. This concludes the fair housing, essentials of fair housing training. I want to thank everyone for being on the training with me today. I certainly hope you had at least one takeaway. I hope it was several, but I'll take it if you had at least one. I wish you all a great rest of the day. And again, thank you for joining me. I hope everybody has a good day. Thank you. Oh, you're welcome. Thank you.